You're Free to Go is sponsored by Milburn Men's Clothing, where top athletes shop for sharp, tailored style. And whether Marc and I are in the studio or the courtroom, Milburn dresses us for success. Mention YFTG and get 10% off at Milburn Men's Clothing, which has been providing the finest in men's clothing and suits since 1946. Call 651-645-2922 or visit www.milburn.com. Hey everybody, welcome back to You're Free to Go. Marc and I hope you've been enjoying our episodes as much as we've been enjoying sharing with you the stories and our cases and our experiences over the last, combined 70 to 80 years, a long time in the trenches.
Don't remind me.
Right. Yeah. Loving every minute of it, that's for sure. You know, this podcast is, we're having so much fun with it, but we'd be remiss if we didn't thank two really important people that are helping us make this happen. Our creator and producer, Callie Pines, couldn't have done it without her. And also we need to thank our engineer and producer, Ben Castro from Podcast Junkies. He's really bringing this to life for us, and we're so thankful to both of them. You know that this podcast, You're Free to Go, is real lawyers talking about our real cases. And as it's evolved, we've been hearing feedback from our listeners that they really enjoy hearing some episodes about our crazy-ass cases, and other episodes we talk about nuances of the criminal justice system, the defending a client. You may recall an episode about misidentification of defendants, or we did an episode recently about, do our clients tell us if they're guilty or not? Do we want to know if they're guilty? How do we defend someone who's guilty? So because the feedback has been that they're really enjoying these two different types of episodes, we're going to continue bringing them to you. And hopefully you'll continue to enjoy them and tune in each week with us. Today, we're going to stick to the topic of nuances of the criminal system. And we're going to go and discuss the jury system, jury selection,
Oh boy.
crazy jury stories. As you can imagine, it's a very interesting and very overwhelming topic. So we're not going to finish it in one episode, but what I can assure you is that in every episode going forward, anytime we talk about a case, there will be discussion about jurors or the jury system or the selection of a jury. It's just such an important part of the criminal justice system and what Marc and I do as trial attorneys that inevitably, every time we talk about a case, there is going to be some aspect of that discussion that will address the jury system. So today,
Guy, I have to interject and tell the viewers that, in my somewhat close to 300 jury trials across the United States, I have never, except for one time, waived the jury and what proceeded with the judge. Now, I know a lot of people have judge trials only, but I've always believed in the jury system. And I think it's, frankly, having handled cases in other countries, for U.S. citizens, I can tell you where there aren't juries, it's very difficult. I think it's the bedrock of our justice system, the thing that keeps it going. And I just hope nobody ever thinks about abolishing it. I don't know how they can, because it's kind of written into the Constitution. But be as it may, it really is the most important aspect. And frankly, it's the most important aspect of a trial. Because no matter how well you prepare, and you know this guy, how well you prepare, how good the evidence is for you, or in some cases against you, at the end of the day, it's going to be up to a group of people sitting on the jury who are going to be hearing the case for the first time. And they have a sometimes different perspective. Sometimes we've interviewed juries after the trial and listened to their take on the case, and we go, wait a second, were they listening to the same case that we were presenting? Because they just had a completely different view of things. They took it in a completely different fashion.
There's so much.
That's something we lawyers have to take into account.
There is so much to unpack what you just mentioned, several things. Jury selection you're talking about. We don't know them. They don't know us. We've spent a few minutes. So we're going to talk about how do you pick a jury. You mentioned, waiving your right to jury. I agree. I've hardly ever done that in my career, but I just want to do a shout out to the late, great judge, Barry Cohen, who I think you remember, Mark.
Sure.
He's the only judge that defense attorneys would waive jury for because he was so liberal, so defense oriented that even the prosecutor's office filed bar complaints with the Florida Supreme Court against him for being too defense minded. But yeah, it's almost close to a legal malpractice when a defense attorney encourages their client to waive the jury.
Well,
But
there are some cases,
yeah,
Guy, where it would inflame the jury's passions so much. Sometimes people in cases involving child molestation or other crimes that jurors just would be so repulsed by. I know lawyers from time to time have decided to go via the judge and rely on, the legal arguments and hope that the judge is more impartial than a jury might be. But those are rare cases.
right.
And I personally have not been involved in them.
You know where I sometimes consider it, Mark, is, and we handle cases from the smallest, a simple DUI with no car accident, no injuries, a first DUI, all the way up to major Ponzi schemes or murder or, all sorts of crime, burglaries, drug trafficking. But on the simplest DUI, sometimes I think about going non-jury because the judge has literally sat through 2,000 DUI trials and they've seen those DUI videos when a juror has never seen it before. This is their first time being exposed to a DUI video. And they might look at it and see someone who's a little unstable on their feet and immediately think, oh, they're impaired. They have to find them guilty of DUI. While a judge who's seen 1,000 or 2,000 of these videos can put it in perspective and say, wow, compared to the 1,999 other videos I've seen, this individual looks pretty darn sober to me. So occasionally when the video evidence is really favorable for my client in a DUI, that's when I occasionally think about going, but it gets back to the issue of a jury has to come back with a unanimous verdict. And if it's not unanimous, then it's a hung jury, which means the case can either be retried or the person can enter an agreement to plea it out, or the government might drop the charges. So
Yeah, well, we'll talk about hung juries later on. But, you raise an interesting point. It's that individual jurors' personal perception, what they bring into the courtroom in terms of their life experience that really matters. And that's why questioning them in the process that we commonly refer to as voir dire, which translation is to speak the truth. Um, Lawyers are generally, certainly in state courts, given the opportunity to question jurors and determine their qualifications to sit as fair and impartial jurors. And the problem is that a lot of times lawyers make the mistake of doing so much talking, because we all like to talk, obviously, um, that they don't listen and they don't ask open-ended questions enough. The idea is to learn as much as you can about that individual juror during the time that you have allotted to question them and try to expose if they have biases that you think will be against your client or against the theories of your case. And in some instances, if you can expose it well enough, you can get the judge to kick them off on what we call a challenge for cause. At a minimum, you have a certain number of what we call peremptory challenges, which is to just excuse them for no reason that you have to give, except obviously there are guidelines to that. You can't excuse jurors for racial reasons, and we can get into that at another time.
I literally
But
once excused a juror because they reminded me of my first grade teacher who I couldn't stand. And I used a peremptory challenge just to get her off. I didn't want to be reminded of that for a 5-day trial.
that's a
Yeah,
good point. And
yeah,
sometimes I've asked my client, I said, take a look at the people sitting there that are prospective jurors that we have to select from. If there's anybody that you look at and you just think you're going to hate them, and well, chances are that will get translated in body language during the course of certainly a lengthy trial.
well, you're
And
right.
sometimes it's based on personal experience that your client may have had with somebody who looks like that and the interaction. There are so many nuanced portions to jury selection. It is not a science, it is at best an art.
Right.
But, there's crazy things that happen during it, Guy.
No, but
And we did promise these people we tell them some
okay.
stories, right?
Yeah, I'm gonna let you tell the first one, but before we get to your first story, you talk about the defendant who's sitting next to us looking at the jury, and you're right. If someone's really bothering them that they're looking at, and it just stirs up a negative emotion, the jury could pick up on that. But that also applies to us as the lawyers. And I'm going to share a story that my first day as a prosecutor, when I was being trained, I had just graduated law school, just passed the bar. I get assigned, I get hired, I get assigned a supervisor to train me. And they gave me this advice. When you pick a jury, they said, make sure there's someone on there that you find attractive, because that means every time you look at them, you're going to present your best foot forward. You're going to be smiling. You're going to look great because the jury will pick up on your energy. So it doesn't only, affect the advice that you and I always give to our clients, but also us as the lawyer, the trial attorney, has to kind of keep that in mind as well. But let's get back. Let's get started with some good stories, Mark, because I know we both
Well,
have
I've
some.
had some crazy experiences over the years in picking jury. And one of the things I got to point out, the differences between the state systems and the federal courts. Most state courts in criminal cases allow lawyers to ask questions, a lot of questions of prospective jurors, because you got to find out their biases and you got to expose people that may be against your theory of the case or certainly have a problem with your client and prejudge your client. And for that matter, that's why I always say the concept of voir dire, which is typically called jury selection, is a misnomer. It's really bad juror exclusion. The
Right.
idea is to get rid of the person that you know is not going to judge your case fairly.
Yeah.
And of course, if you go so far as to try to identify somebody that you think is already in your camp, well, obviously the other side is going to be smart enough to kick them off
Right.
or find a way to use a peremptory challenge, or if it is appropriate, a challenge for cause.
Well, I
So
think you're doing a good
picking
thing.
juries is an interesting experience, but in
Right.
terms of crazy stories, I've got a bunch of them. But one that sticks out is, call this in the realm of the unexpected. Certainly in federal court, jurors have a tendency over the years, I've noticed, to dress a little bit more formal and to a lot of men, older men especially, come in shirts and ties and jackets, depending on the locale. And I had a case in Miami years ago in federal court in front of a very tough judge who had absolutely no patience for anything. And we had a jury selection that seemed to be going smoothly, although it was, as typical in federal court, not much you learn because you're not allowed to ask questions. In that case, judge asked all the questions. And we had this elderly gentleman dressed in a shirt and tie and sport jacket, and he just appeared to be very conservative from just the way his demeanor was. And the judge asked him a question, and just out of the blue, this elderly gentleman said, "Yes, dear." And
But
we all kind of like wondered if we heard that right. And the judge said, "Excuse me, did you say yes, dear?" Um, and he replied, "Yes, dear. That's what I said. Yes,
and
dear."
this is a male
Now we're
judge.
totally confused what's
It,
going on.
it's a male
And then,
judge, right?
yeah, male judge.
Okay.
And then I forgot to mention that. Good point. And so, and it was just so out of character for this fellow on the jury, this elderly gentleman. So the judge said, "Well, um, are you understanding what I'm saying?" And the juror responded back, "Yes, dear, I am." And now all the lawyers are looking at each other like, what the
You
heck is going
wondering,
on?
Miami could be a language barrier. Maybe they're speaking in English in the courtroom, which they do, but he maybe speaks Spanish or that's his native
No,
language.
this guy spoke perfect English, and in
Wow,
fact, from his surname, he did not appear to be Hispanic.
interesting.
Seemed to understand English perfectly well. And then the judge says, "Well, it's important that you understand my questions." And the guy goes, "Of course, dear."
Oh boy.
So the judge at that point calls all the lawyers up
Are you
and
thinking
says,
are you thinking this is someone who's trying to get off the jury at this point, Mark?
you know, you know, there have been so many times that people try to get off the jury,
Right.
and by the way, I should caution people who try to do that, that judges are very sensitive to that, and if they pick up that you're trying to get off the jury, well, they'll make sure that you stay on that jury, or they'll make sure you stay around to be seated in other courtrooms for other jury selections till the end of time.
Right, and it also
So, of
goes
course,
back
you
it goes back to what you said about 7, 8 minutes ago about how, countries around the world don't offer juries. It's the greatest system in the world that when someone's accused of a crime, that they have the right to be judged by their peers. It's an honor. As much as it's an inconvenience, it's much more of an honor, and we need to take this seriously. And I have so many people call me and say, "Hey, can you get me out of jury duty? I just got subpoenaed." But it should be something that we do, and we feel proud and honored to show up. And I mean, I've sat in the jury. I've shown up for jury. I never get selected because of the nature of our profession, but I like to sit there and go through it because it is the greatest system in the world. And it's a shame when we see it all the time, jury selection, where people, we know they're just trying to answer our questions or the judge's questions in a way to get them thrown off the jury. And I understand why they don't want to be there. It's, you're getting a couple bucks a day for your service and maybe free parking, and they throw you a Subway sandwich, and you're missing work. So I get it. I know why people don't want to
Yeah,
do jury
well,
duty.
that's why we always
No.
have to be vigilant about. But this guy did not appear that he was trying to get off the jury. So then we all went up to the bench. The judge said, "Well, I don't know what's going on with this guy, but does anybody have a suggestion?" And I felt like saying to the judge, "Yes, dear," but I wasn't. I wasn't going to risk that. So I think one of the lawyers said, "Well, why don't we question him a little bit more?" And I got the sense the lawyer was just looking for us all to have a good time.
Right, a little
So
entertainment.
the judge says, "All right, step back." So we all sat down again, and the judge says, "No, sir, you keep saying dear. Is there any particular reason, something to do with your upbringing, your culture, your language that causes you to use the word dear?" The guy goes, "No, dear."
Come
So
on.
now we're totally mystified. So then the judge calls us up again and says, "All right, we're getting rid of this guy. Anybody have an objection?" We all said no. And so the judge, we all go back. The judge says, "Mr. So and so, we want to thank you for appearing for your service, but we're going to excuse you." And he says, sure, says, "Thank you so much, dear. You've been a wonderful dear. And I thank all you dear lawyers."
Oh my God. That
And then
was
he left. And now we're convinced this guy was trained. This guy figured it out how to get off the
right.
case.
And
But nobody wanted any part of him. But you have crazy situations. I had another case where we're waiting for people to be seated in what we call the box, which is the chairs
well,
that prospective jurors are going to be
Well,
selected from.
Mark, a lot of people have never, it's surprising, but a lot of people have never been called for jury duty. So I'm just going to briefly, tell them you get subpoenaed, you show up at the courthouse, you'll sit in a room with like 300 to 400 other people, and you just sit there and wait. They usually have a big screen TV, kind of lay
Yeah, they give you a tutorial.
yeah, they give you a tutorial what to expect. You sit, you wait. They keep calling people's names out and saying you're coming to this courtroom or that courtroom, and you're waiting for your name to get called. Finally, your name gets called. You get brought to a courtroom, and there's back information like how long is this trial going to last? How complicated is the trial? How many witnesses? So how many people do we think we need? So they'll bring in, you referenced the veneer. It's the group of potential jurors. Sometimes if it's a jury of 6 people, they'll maybe bring 30 people up to that courtroom. If it's a larger jury, they may, or a high profile case where there's going to be, conflicts and so forth, they may bring 30 or 40 or 50 or even 200 people up for the veneer, and go forward. And then you sit in the courtroom, and as you mentioned earlier, the judge can ask some questions in state court. The state and the defense get to ask some questions. Federal court, you don't really get to ask questions, just the judge. So that's kind of the big picture of how this whole process works. So I
Right.
want
And
to,
one of the questions that's asked commonly is of the juror, prospective juror, is do you recognize or do you know anybody in the courtroom, such as any of the lawyers or the defendant? And they sometimes read off the name of prospective witnesses and ask the juror if they know any of those people. I had a situation that, oh my God, it went from bad to chaos
Oh boy.
as a result of that question. As the jury was being seated in the box, the prospective jurors, my client grabs my arm and says, "That's my ex-wife."
Oh no.
And I said, Wait a second. I thought your ex-wife's name was Janice. They announced the prospective juror's name. It wasn't Janice." He said, "No, no, that's my first ex-wife."
Oh, how many
So
wives
how
this
many
guy have?
ex-wives did you
Right?
have?
Yeah.
He's been married 3 times, apparently. I learned that particular moment,
Moment.
and he never told me about the first marriage. In any event, he said, "And if she's asked any questions, she is gonna destroy me." And I realized one of the questions that's gonna be asked is, do you know anybody who's here in the courtroom? Any of the witnesses, any of the defendant or the lawyers? And so I tried to go up to the bench, what we call, approach the bench, ask the judge for what we call a sidebar.
Right, and when there's a
And
sidebar, what's really cool is the judge, it's a very private conversation outside the hearing of the jury or anyone in the gallery that's in there, the public that show up for the trial. And the judge typically turns a little button on that will make a humming noise. So it tunes out the rest of the room so they can't hear this very private, high level discussion that needs to be had so that it doesn't prejudice other jurors and potentially potential witnesses that might be there. Also, sometimes it's supposed to also keep the recording going so that the record is clear, but at the same time, the sound machine tunes it out so others can't hear this conversation. It's an
although
interesting.
it's been my experience sometimes that depending on the size of the courtroom and the volume of the white noise or whatever that contraption is, uh, the jurors wind up hearing things, or
That's right.
lawyers talk too loud, or
It's
if
not
it's a
that far.
case of,
Sometimes it's only a couple
yeah,
feet away. Yeah,
right. So
yeah.
the better approach is for the judge, if it's a serious matter that the jury should not hear, is to just let the jury go back into the jury room, excuse the jury, and so then there's no chance of the jury learning about it. But a lot of judges don't want to do that, and for the same reason, because it slows up the trial and interrupts things from moving along,
And
cohesively.
yeah, there's a real
Judges
art.
also have a tendency, some judges, many judges, and I found this mostly in federal court, have a tendency not to want to have too many sidebars. They'll
Right.
say to the lawyer, "Well, wait till we take a break and then you can put it on the record."
Yeah.
Sometimes, though, you have to address it right there. And I wanted a sidebar because I wanted to tell the judge, we don't want to ask any questions of this woman because it's going to be a disaster. And obviously, she should be excused for cause.
Yeah.
Well, the judge wouldn't give me a sidebar at that particular moment. So now I'm deciding what the heck I'm going to do. So I'm waiting. I'm hoping the judge is not going to ask her too many questions. And I'm certainly hoping that when he asks her, if you know anybody, she's just going to say, well, I know the defendant. Maybe he'll allow her to approach sidebar. So he asked this particular juror, the ex-wife, do you know anybody here in the courtroom, any of the parties? And she said, yeah, I know the defendant. I used to be married to him.
Oh
And
boy.
he's a lying, cheating son of a bitch.
Oh wait, did the whole jury hear this?
Not only the whole jury here, and everybody started laughing in the
Oh,
courtroom.
oh
And
man.
now I'm going, oh my God. So now I asked for a sidebar. The judge gives me a sidebar. I said, Judge, before this goes any further, I think we should excuse this juror. And on top of it, Judge, I think maybe we should consider excusing the entire panel because they've been tainted.
Well, this
That's
goes
what we
back to,
call,
yeah, poisoning the jury, right?
and not literally poisoning them, although sometimes you'd like to, but
Yeah, because the cat's out of the bag. Like once the genie's out of the bottle, you can't, these jurors, potential jurors, because they're all part of the veneer at this point, they've all heard someone say horrible things about your client in this case. Now, how are they going to forget that and move forward and give him a fair and impartial trial? So
right.
the whole
But
jury is
typical of
poisoned.
judges, this particular judge did not want to excuse the juror at that moment, nor did he want to even entertain a uh, a mistrial. Well, there wasn't even a mistrial at that point. Just excuse the panel. So the panel hadn't been sworn in. The jury hadn't been sworn in, so a mistrial would not be appropriate yet. Case hadn't formally begun. So I didn't know what to do. I went back and I said to my client, "Is there anything you can tell me about this woman that helped me so I can question her and maybe diffuse what she's already said?" And he told me, "Well, on top of the fact that she's been arrested several times for domestic violence on me and our kids, she was also charged with kidnapping. She pled guilty to something, assault or something involving our oldest son."
It,
Um,
it sounds like you're
I said,
actually.
"Well,
It sounds like you're in divorce court, not in jury
right,
selection, right?
right." And I said, "Well, that's interesting." I said, "Is there anything else you can tell me?" Yeah, she was accused of perjury in court, um, and that was dropped. But the best part is she got nothing from me in the divorce.
Oh yeah.
She didn't get what she wanted, which was obviously the thing that I played with when I got to question her, to try to point out her bias, that she hates my client. And I brought up the fact of her arrest and her conviction, and I left it alone. I don't know if it made any
Mm.
difference. Obviously, the jury knew that my client, but the thing that I think they heard that a couple of the women on the jury didn't like is she said he was a cheater. And I
Yeah.
had nothing to do with that
And
on
what
any questioning.
and what you were doing as a good lawyer is trying to rehabilitate that situation. We do it all the time when there's something that
Right.
comes out in testimony or in jury selection that hurts our client. We rehabilitate. So I'm sure you did a good job with that.
Well,
I
interesting
think. By
part of
the way,
that
Marc,
case is,
I think Ben, our
yeah.
producer, has a question.
Oh, sure, Ben, go
Yeah.
ahead.
Hey guys. So I'm sitting here kind of just assessing. So is there times where you interview every single person on the jury? Or is it just,
Well,
or is there times where you were to just be like, oh, all right, no problems. We don't have to talk to anybody on the jury. And we're just going to go along with the case.
well, I think the best way to answer that, it first depends on the time you're allotted to question. And as I said, in federal court, even though traditionally lawyers were not being given the opportunity to question jurors, and the voir dire was done by the judge, and it was totally ineffective. It didn't reveal anything of merit. It was really a waste. But most of the younger and more enlightened judges and federal bench are allowing some form of voir dire, but they're limiting the time. It's not like it is in state court. So if you have very short period of time, first of all, if you know you like somebody or you don't think they're going to be a problem, or you're certainly sure you're going to bump them off because of their answers to some of the judges' questions, you may skip over them.
Right.
So the answer is you rarely get to question everybody in the jury in the typical way jury selection is done. Although there are a lot of different ways it is done in different locales, different jurisdictions. But typically you question the people that are brought up to sit in the jury box. And those are the ones that you question.
Gotcha.
Because it may make no sense to question somebody who's number 66 in the back that you'll never get to.
Gotcha.
Right. I want to give that mile high view again. If it's a 30-person veneer, meaning out of those 30, you're going to pick, say, a 6-person jury. The judge might say, well, we need an alternate in case someone gets sick. It's a 3-day trial. Someone might get sick and not show up on day 2. So let's pick 7. The first 6 that get picked are the jurors. Number 7 is an alternate if someone doesn't show up or has a problem. So if 30 people come in the room, and this is a good hint for anyone who ever gets called to jury duty, if you're in one of the first 6 seats, you guys are in the hot seat. You have a very good chance of being picked, because what happens is we start doing the jury elimination or jury selection, and you might get down the road to number 10 or 11 or 12, but the guys, like Marc just said, way in the back, odds are the lawyers aren't going to get that far down into the group, and you won't be selected. So it's really the first couple. But I did play a trick many times, a little strategy. There's a lot of science to how to pick a jury. When I was a prosecutor, I would listen to the judge would ask all their questions. And in cases where the defense and state prosecutor got to ask questions, we'd ask ours as well. And then I would stand up as a prosecutor and say, well, we're fine with the first 6, no problem. and then I'd let the defense go, because once the defense started picking, we got a very good idea of maybe what their strategy was, what jurors they liked or didn't like. Because typically people are on the state-oriented side. Not always, of course, but they're very often. So I played that trick a few times, and it was very helpful to just, because that was a good question you asked, Ben. Like, can you just say, okay, we'll take these people? Occasionally, strategically, I would do that, and it usually played out pretty well. Because then the defense, when they start picking, you see what they're really they're showing you their cards.
Wow.
What they're going for.
That's very fascinating.
But and Marc, you know,
Yeah, there are a lot of tricks, but the problem with the tricks are you have to know where you are. I mean, having the benefit of trying cases all over the country, you know, each jurisdiction is different. Some courts, they allow what's called backstriking, which is after you've selected people and there's still people remaining, you can go back and strike the ones that you've left on, that you haven't kicked off yet.
You could be on the
And that-
14th person and say, "Oh, I'm going to backstrike number 2," is what he's saying, right?
Right.
Yeah.
And so it gets very complicated. And the problem also is the amount of time that you have to do it. You know, what are the ways you learn about somebody? Now, with the advent of social media, that has actually benefited lawyers in their ability to select jurors, because if you have a team of people who are doing social media research while you are questioning the juror, while the juror is there and you know their name and you know where they, you know, the area that they live, at that point, you can have people go on social media, see if your prospective juror has posted anything. I mean, in the old days, we used to ask questions before social media, kind of betrays my age. We used to ask people if they had any bumper stickers.
Oh
Because
yeah.
sometimes people would portray their very strong passions with bumper stickers. And I remember one crazy case.
Free to Go is sponsored by Lang Realty, South Florida's premier residential real estate broker. Whether you're buying, selling, or renting a home or condo, Lang's experienced realtors are standing by ready to help you. Contact one of Lang's top realtors today at 561-703-2427.
Where I was asking this juror if he had any bumper stickers, and he said yes. And I said, well, what does it say? And he says on one side of the back of my car, it said, "Jesus saves." I'm thinking, oh, okay, he's a religious man. And then without skipping a beat, he says, but on the other side says, but Gretzky scores. Obviously, now I know he's a hockey fan,
right.
and he's somewhat irreverent. So it gave you a little insight to the personality of the individual. Now with social media, you can find out people's postings, and you can see whether or not, you know, for example, if they have any racial bias, if they had any strong political views, you know, if they're a gun person or not. You know, there are a lot of different things that may factor into a case that, you know, you might learn from their social media postings. And if you have the time to, you know, get back to the person, or the person comes up from the back of the courtroom, or they're sitting next to you and doing it on the computer and they can give you that info, you can use it effectively.
You know, and there's a real art to that, but I just want our listeners and viewers to understand that there was a Gene Hackman movie once, I forget the name of it, but also...
Oh, yes, it was... with John Cusack.
Yeah, and then, you know, and then there was that
movie.
TV show Bull. These guys are using I want everyone to understand that stuff is just make-believe for television, where they're watching the person on the jury, they start to sweat, and they're taking their temperature, and they're looking at, like, all that high-tech, that stuff's not real, but having jury selection experts sit by our side when we're picking a jury is real, and they, you know, they analyze, they come from a psychological background, psychology, and they really do, like you said, look at those types of things. Before Ben asks his next question, though, I do need to touch on two comments you made. One is how we've handled cases around the country, And there are places around the country where it's very difficult for the prosecutor to pick a jury. I mentioned earlier my experience as a prosecutor, I'd say I'd take the first 6. There are a lot of communities around the country where people just do not trust the police. And so a prosecutor is trying to pursue a case and they know their lead witnesses are going to be police officers, but they're in a community where no one believes the police. So that's hard. And number 2, before I get to Ben, is you started this whole discussion a minute or two ago about the question on that jurors get asked, do you know anyone in the courtroom? And I just have to share this really quick story because very often, because of what we do, Mark, in our high-profile cases, jurors will say, oh, I've seen him on TV before. I know he's handled these cases. And the judge, that's okay. They're still able to be fair and impartial. But one time a juror stood up and said, I know Mr. Fronstin. My husband is a national attorney in estate planning, and he said that Mr. Fronstin's the best criminal defense lawyer in the entire world, and if any of our children ever get in trouble, we've got to hire him because no matter what they've done, Mr. Fronstin will get them out of trouble. Now, I loved that. I thought it was great. It was a great endorsement. I think every person in that jury pool will hire me if they ever need somebody. But at that point, the prosecutor couldn't rehabilitate them because they figured no matter what, how are they going to rule against me and my client? So, all right, I had to share that because I'll never forget that was a great story that happened.
No, and that's a perfect example, Guy, of what we were talking about, of identifying somebody who might be so favorable to you that the other side is clearly going to dump them.
Right.
And that's exactly what happened in that case. But, talking about
Ben, hold your question, Ben.
I'll hold my question. I'll hold my question.
Okay.
Oh, yeah, I just have to mention one thing. And, there's a federal court in Key West. And as you know, Key West is one of the most laid-back places in the country. And I think formal wear is just clean shorts and a clean T-shirt. And I remember having a number of cases in Key West back in the 80s and 90s, a lot of drug cases. Prosecutors were having a hard time getting convictions in Key West because most of the panel of prospective jurors were retired smugglers.
Right.
Retired marijuana smugglers.
They're criminals
So
themselves.
that was the joke.
Right. All right, Ben, what's up?
Well, so you were speaking about the bumper stickers that really intrigued me. I thought that was really interesting. Now it brought me to another question about like tattoos. Has there ever been a case where someone's tattoo on their body, of course you can be identified, and that, but like has given them away in the sense of not like almost for what they like or things that like they're just as like the bumper stickers,
Well, recently, that's a good question. Recently, I had a case here in LA where one of the prospective jurors had tattoos on his face. And the first thing that came to mind, because of the nature of their tattoos, is, was he potentially a gang member? And obviously the prosecutor picked up on that right away and started asking questions, but didn't want to piss him off by suggesting that he was a member of a gang. So he was kind of dancing around about it. And then at one point he asked the fellow, does he have any other tattoos? And the guy started unbuttoning his shirt, and he had tattoos everywhere. He didn't obviously open his shirt. He had sleeves, he had everything. He said there were very few parts of his body that wasn't tattooed. And that gave us an idea that we're dealing with an individual who might go very favorably for the defendant in a drug case, which it was, and the prosecutor bumped him off. But of course, you never really know.
Yeah, I had in my last trial, excuse me, a juror had a tattoo that was talked about forgiveness and judgment. So when you're on a jury, you have to be fair and impartial, and you may be judging somebody. And so I dove very deep into questioning him about, do you feel you have the ability to judge? And he said, no, that's God's prerogative. It's not my place as a human being to judge. And he could not sit on this jury. And I never would have known that. Maybe it would have come out some other way, but it was because of the tattoo that I saw on his arm that led me down that line of questioning. It was pretty cool.
That's right.
Yeah.
So those.
Well, thank you.
Those things
that was
can be
pretty
useful.
interesting. Yeah.
I want to also mention another crazy situation involving jurors or prospective jurors during jury selection. I had a case, and I noticed this fellow sitting in the box who just got seated as a prospective juror. we're going to ask some questions. And I immediately recognized him. He was a co-defendant of a client of mine in another case that wound up getting mistried because it was a hung jury. So the case was still pending, hadn't been brought to trial again. But this fellow had been arrested. He was a defendant in a very serious drug case. And when the judge asked the jury panel, has anybody here ever been arrested, or anyone close to them had been arrested, a family member? He didn't raise his hand. And I knew that
Right.
clearly he not only had been arrested, he was pending trial. And if he got convicted, he would go away for a very long period of time. So it raised a very interesting ethical problem. Do I raise it? Because obviously I would figure he might be very favorable to my
Favorable.
client, but there was no question. I had to bring it to the court's attention. So I asked for a sidebar. I had a judge who allowed the sidebar, and I told the judge exactly what I knew. The judge was just mystified because this fellow is, when you're questioned, you're already placed under oath, supposed to answer those questions truthfully. You could be subject to penalties of perjury or of making false statements, and a minimum contempt of court. So the judge excused the jury panel, left the guy sitting there by himself, and started questioning him and asked him, well, Mr. So-and-so, and I'd given the judge the name of the case and the judge that the other case was in front of. And the judge asked, well, Mr. So-and-so, were you a defendant in this case? Were you arrested? And the guy kept saying no. So I'm wondering, maybe I
Have him
maybe I
confused.
dreamt this.
Right.
Obviously not.
Hmm.
And so the judge says, well, we're going to excuse you, sir, but you're not to leave the courthouse. And he placed him in temporary marshal's custody.
Wow.
So
Yeah.
that's basically being under arrest. I don't know what ultimately happened to the fellow, but interestingly, when the case came to trial the second time, he was nowhere to be found. Apparently, he had pled guilty.
And I guess the point
So,
there too is, like you said, that he was sworn in to tell the truth, and the questions are being asked you in the court of law. And when you lie, you can actually be held in contempt of court. And
yeah,
the judge can have proceedings against you. I've seen it happen. We talk about, most people seem to want to get off jurors, but occasionally you'll have someone lie to get on a jury. I'll talk in one of our future episodes about a high-profile case where this juror lied to get on the jury because they knew it would be high-profile. They wanted to be there. And who knows if that's what that gentleman was doing or not. But when they do, if lie to the judge, they can be held in contempt if people find out that you're lying. It's very, very serious.
right. And talking about wanting to be on the jury, I had a particular federal judge. I won't mention where, and I certainly won't mention names, but he had a habit of calling the prosecutor, the U.S. attorney, and I up during jury selection and saying, you see juror number 9 over there? I would like her to be on the jury.
Oh, okay.
She obviously was a beautiful woman, and he was a bit known as a skirt chaser. And so I remember the first time it happened, I looked at the U.S. attorney. I said, well, what are you going to do? What do you want to do? You have any problem with her? I said, I had no problem with her. He had no problem with her. So, we kept her on the jury, and it was like we had a very attractive person to talk to actually, it was a good looking jury all around. And then the second time it happened, about a year later or so, a different prosecutor. This time he just didn't want that person on the jury. And he said to me, but I don't want to tick off the judge. So I'm going to be okay with it. And we let that particular woman on the jury as well. The third time, though, 3 strikes, you're out. There was a person on the jury, and she said some things during jury selection that was clear to me. There was no way, even if this judge didn't like me, I don't care if the judge likes me or not. If the judge was going to be ticked off, whatever. I'm not picking her. So I tried to excuse her for cause because she said things that clearly were, of the like that she should have been kicked off for clear, demonstrable bias, but the judge refused. He punished me by making me use one of my limited number of peremptory challenges. But, all sorts of strange things happen during jury selection because at the end of the day, you're dealing with people.
Right. And what I was once trained or taught when I used a jury consultant early on to help select the jury was they recommend keeping a wild card on there. You're talking about some kind of people answering questions a little bit crazy, a little bit offhanded. Sometimes as a defense attorney, you keep that wild card on there so that if you do get a guilty verdict, maybe you can dig a little bit into that wild card that was on the jury, and maybe you'll find something that was improper that might give you the basis for a motion for a new trial.
Well, that's a good point, Guy. And to kind of wrap this up, because I know we're running out of time, in that vein, where I've had cases where I know there's no way we're going to win, it would be a shot in the dark. It would be literally weekend at Bernie's, like I call it. But we've been given no choice but to go to trial, and the client insists on going to trial. And you never know, anything can happen. In those cases, sometimes you pray for a hung jury. You get at least one person who votes not guilty, and then the jury's deadlocked. The jury can't reach a unanimous verdict, and the case gets mistried, and then it has to be tried again. And often in those situations, you may be able to work out some kind of favorable plea deal. So when we had one of those cases, I had a great jury selection expert, and we decided we were going to try to find our Newman on the jury. And at the time, Seinfeld was a very popular show on TV, wasn't in reruns. And, Newman was this kind of unlikable, crazy guy.
Newman.
And played by Wayne Knight. And so we wanted to find the guy that nobody else on the jury would like. And we were studying, and the jury selection took a long time, and we hadn't even completed it. And they had already gone out twice, 2 days for lunch. And one of the things we noticed was he went out to lunch by himself, whereas other jurors were in groups of people. Both days, he was a complete loner. And there was something about the guy that gave us the sense that maybe he might be our Newman. So we wound up picking him on the jury. First of all, the crazy part about this, truth is stranger than fiction. He was a postal worker, just like Newman in the show. Well, we wound up with a hung jury. Now, we never knew for sure whether it was him, but we suspected he was one of the not guilties, just couldn't tell for sure. But it was a funny situation. So, it's like I say, you're right. There is some science to it, but it's still mostly an art. And, I've taught trial lawyering in law school. And when it gets to trying to teach about voir dire, it's hard to teach much other than to let students know, prospective, young potential lawyers, let the jurors talk, find out as much as you can.
Right. And we learn, like you said, it's hard to teach that, and you learn from experience. That's why between the two of us, we've had hundreds and hundreds of jury trials that we've learned and amassed a tremendous amount of knowledge from. One of the most important things for me with jury selection to learn from is when I'm fortunate enough to have a judge that at the end of the trial says to the jury, thank you for your service, no matter what the verdict is, whether it's guilty, not guilty, or hung jury, thank you for your service. And by the way, if you would like to speak to the lawyers about the lawyers would love to hear from you. You're not obligated or required by law by any means to talk to the jurors or to talk to anyone about this case. But I'm going to tell you that the lawyers would love to hear from you guys after you're released from your obligation here. So please, and I get so much information and knowledge. Something as simple as I focused on a point that I thought was important, that the jury comes back and says, we didn't think that was important. We thought this point was important. And I didn't think that it was. So I learned so much over the years from just talking with jurors afterwards. And it takes a judge.
Yeah, but you have to beware to trust them completely, because there's this, typical part of human nature that when they're standing face to face to you, they may not want to tell you the, disagreeable things to your face. I remember one case where a federal judge told the jury in New York after a hung jury, that, if they want to hang around the jury room, the lawyers will come back and talk to them. They don't have to. And so we went back. There was about 6 or 7 of the jurors there. And I remember cornering one of them with the other defense attorneys. And we started asking questions. This juror told me, "Oh, I voted not guilty. I thought your client was innocent, blah, blah, blah." Went through this whole explanation. Sounded really good. Then we moved on. We thanked that person, moved on to somebody else. And then I hear that person, talking to the prosecutor and saying the exact opposite, telling the prosecutor that she would have voted guilty.
Right. I remember you told me about that. You are right.
Yeah. So, you
Yeah.
just have to be careful. People have a tendency not to want to tell you disagreeable things to your face.
Right.
But be as it may, it's a fascinating topic. We're going to be able to go at it again and again over time and tell more stories. But I think our time is wrapping up. And for our
Yeah.
next session, we're going to be talking about more of our crazy cases. I'm
Right.
going to be telling a story about the client who flew the coop, so to speak, while on bond and wound up getting arrested and wound up in a prison in Portugal, and something right out of the movies, the worst possible place you could be. And it was just an absolutely crazy result in that case.
Yeah.
And I'm sure you've got some crazy cases, Guy, too, right?
Well, yeah, I have one for next week that we're going to tie into today's topic. It was an extremely high-profile trial. The government spent a lot of money prosecuting this case. It was all over the news. It was a long, long trial. And at the end of the day, fortunately, I picked a crazy-ass juror to be on that jury. And when we did get the guilty verdict, and I dug deep into this guy's background, it gave me a lot of valuable information to file a motion for new trial, which I won because of this crazy-ass juror that we left on the trial. So I can't wait to talk about that case, which had a lot of twists and turns to it, and tie it into today's topic.
Great, and we've got some more stories as well. So, ladies and gentlemen, until next time,
You're free to go. Down Low Investigations is a sponsor of You're Free to Go. Behind every great criminal defense attorney is a great private investigator. That's why Marc and I use Down Low to investigate cases all over the country. Down Low can help you too, whether you're running a background check on an employee or running a background check on a blind date, or let's say you need someone followed or some other type of investigative work conducted. Down Low is the way to go. Call Download Investigations at 561-843-1806. Everything expressed and discussed in this episode are the opinions and experiences of attorneys Guy Fronstin and Marc Nurik and their guests. All ethical rules are complied with. Attorney-client privilege and confidential information is not shared or released during these episodes, and names, dates, locations, and other identifying information may be changed to protect confidentiality. Topics are embellished, and none of the statements made constitute legal advice and should not be considered or relied on as such.